Breaking, breaking, breaking. While you were away on break, guess what? It's the most amazing day here on Law and Crime. Tammy Mora has elected to testify. I don't know when that's going to be, but she has elected as as her own defense witness to testify. Now, while the jury is coming in, I want to quickly introduce my afternoon guest, Nicole DeBorde. Nicole, are you there? Hi.
Nice
You're
to
always
see you
here on these crazy, wonderful days. And Nicole's a great criminal defense attorney from Texas. Now, Nicole, really quickly, because we may only have 30 seconds, in my experience, when you put a defendant on the stand, the whole case comes down to them, and everything you've done before is gone. What is your experience?
That's 100% true. And really, these are very difficult situations for attorneys, as you can imagine, because as you know, these are decisions that a client makes independently, and you can advise your client to do one thing, and the client can choose to do a completely different thing. So this will be very interesting to see.
And as we're seeing the picture of the courtroom, you're not missing anything yet. As what I have learned, and Nicole, and you probably too, that if you have a client who's going to go against your advice, you certainly want a court reporter in a private room, and you want to take down the fact that they're going against your advice, that you advise them of their rights, you advise them not to testify, and they're agreeing to testify if that's the case. And if it's the other way around, you also want that, because you don't want them later on to come back and say, my attorney told me to testify and I didn't want to. Right? Is that correct?
It's certainly one way to do it. Another way to do it is to have a private written agreement between you and your client. For example, if you have a client, sometimes you don't want to telegraph to the judge that you have a client who isn't doing what you're asking. And it may be appropriate in those circumstances to draft a document saying, I'm advising you to do the following or to not do the following. These are the perceived consequences, potentially, and you're not following that advice, but you're doing so of your own free will.
Now put yourself in the defense attorney's hand. After you've been following this case, which is the most, which to me is a maddening case, as I've said, because I don't think the victim has been done justice, although we don't ever know until the verdict. If you're following this case, would you have advised her to testify?
No.
Now, why not? Tell our listeners, our viewers, why.
You know, I think that this is a case that's really circumstantial. It's a difficult case for the government to make, for the state to make. But when you throw in a volatile, potentially volatile client, who knows what kinds of information she'll confirm or what she may add to the mix, it's not a good risk. Why do it?
So now, if she's going to testify, what's the main focus of her testimony? You're representing her, and I know this. I'm asking for a hard decision because we don't know everything that defense attorneys know. What would you have be her main focus?
You know, it depends on what it is she so badly wants to get up and talk about. I mean, the reality is maybe she has some sort of an alibi, or she has some sort of points that she wants to make about the prosecution's case being wrong or the potential idea for motive being off. You know, I think in this circumstance, it's really going to depend on what problems this particular client perceives with the state's case.
Well, she obviously thinks they have no evidence against her, because our producer, Kathy Russon, heard her say they don't have evidence against me or something to that effect. So obviously she thinks that, and we've talked about that a lot. But should that translate in her mind into a decision that therefore she has to take the stand if they don't have evidence against her?
Why give it to them? If they have no evidence, why offer your own? This is a situation where, you know, to remain quiet is to allow the government or the state to continue to flounder in their prosecution. But
do you think she's going to say her husband did it by herself and she learned of it? Do you think she's going to throw him to the wolves or the alligators, as has been said in this case?
I think it's entirely possible, and I'm sure eager to hear for myself.
Oh my gosh, wouldn't that be interesting? Well, I see the judge is laughing. I don't know why he's laughing, but today, I don't know if you followed this case, but we had some interesting testimony in the courtroom earlier. Her cousin testified that he was brought over at a party, a barbecue, the May after the victim disappeared, Heather Elvis disappeared, and that Sidney Elvis brought him to. Well, let me just give an update to the viewers before we talk more. The jury right now is being dismissed to go home for the day. So the other separate witnesses that indeed the defense has represented to the court that they're going to call, and Tammy's election to testify will not occur today. Obviously, because even though it may be 3:49 here, 2:49, I guess they figure that this is going to take a while, and maybe the defense, who knows, maybe they're asking her to reconsider her decision, who knows. But while we're looking at the judge, that's probably why he's smiling, he's getting to go home early. Did you hear the testimony from the cousin who said that Sidney showed me a picture on a flip phone, say that 10 times, okay? And it looked to be a Heather Elvis, and who was not able to talk or walk. Did you hear that testimony?
I did not hear the testimony, but I'm familiar with the facts that you're describing. And I think that that could be really damning, at least to the husband.
Well, but let me throw another thing in. Then, in cross-examination, it turns out that the defense had a tape that was accidentally given to them, and the prosecution objected to it being put into the courtroom, where the cousin said, oh boy, he was talking to his mom from jail, and he said, why didn't you tell me you saw this photo? And he said, it's a lie, Mom. It's a lie, that he didn't see the photo. And they were able to present that before the jury. So, indeed, this is what we call an incentivized, maybe an incentivized informant, although he denies it, or a jailhouse snitch. What is your experience with the validity of jailhouse snitches, both from your prosecution days and from your defense days?
Oh, these are the worst witnesses. I mean, these are witnesses that are testifying with a motive. They have everything to gain by cooperating with the state and providing the information they think the state wants to hear, because they're hoping to get a sentence reduction or to get some other benefit. And, you know, it's just not trustworthy information.
Yeah, you know, I was on before with Bob Bianchi, who also was the chief prosecutor in a county in New Jersey, which is a big job, okay, and is now a defense witness, as his father had been before him, a trial attorney before him. And Bob made the point that, indeed, these are terrible witnesses for the prosecution. But some of the questions that weren't asked by the defense were you given, well, they did ask that we were given any deals. The prosecution said no, he was given no deals. But has there been any payments made for him being an informant for the police? Has he been arrested or stopped at any other charges that he wasn't charged? Some of those other police questions. Explain to the viewers how having a promise by a prosecution is different than possibly having a promise by the police that may not be in any writings.
You know, sometimes it's a little bit of a trick, quite frankly, that is used to get around the obligations of the state, of the prosecution, to have to turn over information that a witness is essentially being paid in some way, either by a lower sentence or even cash sometimes, you never know, to provide the testimony. Because when a witness is receiving a benefit, it makes them potentially less credible. And so if the police do this and they don't share that information with the state can't share it with the defense, as they're obligated to do. So, you know, you certainly hope that that hasn't occurred. It would not be ethical if that had occurred. But, you know, this is the kind of thing, you know, if you start tricking the jury, you've lost all trust. And for the prosecution, that's a huge problem.
Right, right.
And that's all they've got.
And that's one of the things that Bob and I were talking about. Indeed, you have to have your credibility. That is foremost when you're a trial attorney. Even if some of the people you're bringing forward are not so great, the jury has to believe that you're bringing them forward in good faith. Now,
exactly.
I believe we're looking at pictures. I'm going to ask my pictures. Where are we going now? Because I see we're looking at pictures of the mother of Sydney Moorer right now, right? That's what's on your screen. And she testified earlier today that she hadn't had much contact with Sydney or Tammy for years. And then all of a sudden, what happened? They kind of showed up at the house. And in January of the following year, after Heather Elvis went missing, Sydney came and showed this huge tattoo of the words Tammy across his stomach, all the way across his stomach, a tattoo which she had not seen before. Now, how does that go to prove that Tammy engaged in a conspiracy to commit a kidnapping of somebody who has not been found, who can't say she was kidnapped?
You know, this is a tough situation, again, because, again, the prosecution's case is entirely circumstantial. They're trying to use all these little pieces to show that they have one cohesive story. You know, you add that in combination with this potential failed snitch testimony where he's admitting that he lied, and you have a big problem for the state. I think they're desperate. I think they're reaching to show that there's information here that makes this story add up, and quite frankly, there's just holes in even what they have. Well,
in a murder case, you can show that even though there's no body, that there's been a homicide. You can infer a homicide because the person hasn't appeared, et cetera, et cetera. They haven't banked, they haven't gone to church, they haven't gone shopping. But in a kidnapping, quickly, because we're going to be going to break pretty soon, in a minute actually, in a kidnapping, do you know of any cases where somebody who's been kidnapped has not turned up, whose body's missing, that there's been a successful kidnapping prosecution?
Not that comes to mind. I mean, certainly I think it's the same types of problems you have in a circumstantial case like a murder where you don't have a body, but it is highly unusual. A kidnapping is usually the sort of thing where you have a potential victim who can testify about what happened.
And that's exactly what we're talking about. When Nicole's talking about, the prosecution still has the burden of proof here. The prosecution has to prove beyond a reasonable doubt that indeed Heather Elvis was kidnapped by Tammy Moore, and that they have to prove that with evidence, actual evidence, not innuendo, not suspect, not what we believe, not what I believe, not what you believe, but evidence in court before the jury. So we'll see what's happening, but first we have to go to break. Stay tuned, only here, more and more, gavel to gavel. Hi, welcome back to Law and Crime, the only place you're going to hear about these two cases right now, gavel to gavel. One is the South Carolina versus Tammy Moore, who's on trial for kidnapping and conspiracy to kidnap Heather Elvis. And can't forget, there are victims in these cases. Heather Elvis was 20 years old, last seen years ago. And the second case is Ohio versus Wimpy, the case where Daniel Vasquez died as a result of some conduct that occurred for which the defendant is on trial. But in the meantime, while we're following those cases, and we'll be talking about them for the next hour, by the way, I want you to stay tuned after we do the top crime stories, because it's time to lock up your kids, because we're going to hear about text messages from Tammy Moore to different people. But in the meantime, we have to go to our top afternoon crime stories.
Here are today's top crime stories trending on Law&Crime.com and across the country. A police officer in Maryland is now facing charges after he allegedly raped a woman during a traffic stop. 29-year-old Officer Ryan Macklin reportedly pulled over a driver and then forced her to perform a sexual act. Macklin, a 6-year veteran of the Prince George's County Police Department, was suspended without pay and relieved of his duties. He now faces charges including second-degree rape and perverted practice. A grandmother in Mississippi is under arrest after she allegedly stabbed her 20-month-old granddaughter before baking the toddler's body in an oven. 48-year-old Carolyn Jones was taken into custody after authorities were called to a residence in Shaw where they found the child. Investigators are unsure whether the child was still alive when she was placed in the oven. Jones now faces a charge of first-degree murder. The former president of a Baylor University fraternity accused of sexually assaulting another student in 2015 will likely avoid jail time after taking a plea deal for a lesser charge. 24-year-old Jacob Walter Anderson initially faced 4 counts of sexual assault for the incident at a Phi Delta Theta fraternity party in February of 2015, but pleaded guilty to unlawful restraint and received a slap-on-the-wrist sentence of 3 years probation, a $400 fine, and court-ordered counseling. The victim reportedly filed a civil lawsuit against Anderson, Phi Delta Theta, and the landlord of the home where the assault allegedly occurred. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Okay, so before we go back to Tammy Moore this afternoon with those text messages, again, stay tuned. I'd want to talk to Nicole DeBorde briefly about the top crime stories, specifically the last one, because quite frankly, I can't comprehend any of them. I can't comprehend an officer who rapes a suspect who is accused of it, a grandmother who is accused of baking her grandchild in an oven, and this one where somebody who is charged with rape gets a slap on the wrist and goes home. Nicole, do you understand what's going on in the case?
I don't. It's something that you always have to defer to the people that are hearing all of the details and the facts in the case. I mean, these are certainly bizarre fact scenarios. These are tough cases.
Yeah, but the mother, the victim, came out and said they never talked to anybody. They didn't talk to the Title IX. They didn't talk to anybody. And Baylor was under review a couple years back, if I recall, for some sexual issues, sexual harassment issues, and sexual assault issues. The school regarding Title IX. So why wouldn't he have to register as a sex offender? Why wouldn't you at least give him that?
Well, in Texas, it's not negotiable whether or not someone can be on the sex offender registration. Basically, if you plead guilty to a crime which is listed under the chapter of our code, which dictates which cases require registration, and you're going to be required to register.
But Nicole, I know that, and you're a good defense attorney. You would have gotten this guy the same deal. But if he raped this woman who was not able to give consent, doesn't he deserve to have more than a slap on the wrist?
Well, whatever he deserves versus what he got, you know, there's the registration requirements are what they are. So if Chapter 62 of our code requires a person to register as a sex offender, then that's what's required. If the chapter doesn't list the offense to which he pled, then he's not going to be required to register, and it's not something the prosecution can change.
Wow. I just have to tell you, when I first heard that, and Anthony Velez brings us the most amazing stories every day, quite frankly, I was dumbfounded in this age where rape victims should be taken seriously, and perhaps she was. I'm not accusing anyone of not taking her seriously, but when you see it just on the surface, it does not look good. But along with the other things we're covering here, as you all know, we've been following the case of South Carolina versus Tammy Moore for the conspiracy to kidnap and for the kidnapping of poor 20-year-old Heather Elvis, who has not been seen since December 2013. Now, a body has never been recovered. Murder charges have been dismissed, but there were a lot of forensic evidence that was attempted to be recovered from the phones of both Tammy Moore, who's now on trial, and Sydney Moore, who was on trial for the same charges, and there was a hung jury before Tammy went on trial. Now, one of the things that officers use when they try to look at somebody's phone, like for instance my phone, they use a technology called Celebrite. I know there was some back and forth in the courtroom whether it's called Celebrite or Cellbrite, and in fact, you know, one of the ads for Cellbrite on their web pages is prosecutors need to trust the evidence, and because it is used by both defense experts and prosecution experts to see what is in a phone. For instance, they could track you by your Google locations if you're on Google. They can track you by cell towers if it works properly, but it may not always work properly. So there's been a lot of evidence, but one of the things they recovered here were text messages, and some of them are pretty racy. For the next hour or so, stay tuned, but bring out your popcorn, because you have to kind of separate this from the victim here and just say, who are these people who may have committed the perfect crime? And is Tammy Moore one of them based on these text messages? So that is Detective Will Lynch, who's talking about the texts that were recovered from both Sydney's and Tammy's phone, wherein, and according to him, Tammy has both phones, and they can tell that because she is using both of them pretty much simultaneously to talk to her friend and getting texts in from someone that they have identified as Heather Elvis, they believe, and that they're using language that I am not going to repeat, having graduated from Catholic schools, but you heard the language here. It's pretty bad. Nicole DeBorde, you are a criminal defense attorney, right? Now, Nicole, are you with me still?
I'm here, yeah. I'm here, yeah.
Now, the judge just took an objection that he overruled from the defense that said, hey, you can't tell what the tone is by what's being said by these messages. In other words, there were no animojis or emojis back then. Does that hold water when you have the content that you just heard on these text messages?
I know of no legal objection to tone. And so I don't think that was going to fly. But what I can say is that the defense is going to do anything and everything that they can to try to keep these text messages out, because no matter what you think of the tone, the content is terrible for the defense. So they're trying and they're reaching.
Right. Now, the content is terrible because she's calling Heather Elvis different names. She's calling her the C four-letter word. She's also responding back to Heather Elvis, according to what we can see, and is discussing Sydney, who apparently Heather Elvis used to call Dad in some loving and affectionate way. But how does that get you to conspiracy to kidnap her? Because remember, she's a woman whose husband's had an affair with this younger woman.
Absolutely. I don't think that it does get you to conspiracy, but I do think that the government is trying to do everything they can to dirty up these, the defendant here. I mean, they're trying to show that this was a nasty situation, and reading all of these text messages into the record is one way to do it. But I don't think it gets them there. It just is a tactic, in my opinion, to get the jurors angry.
And so if it doesn't get them to conspiracy, the likelihood, ladies and gentlemen, it doesn't get them to kidnapping if they can't get to conspiracy to kidnapping. But we have to go to break right now. But stay tuned, because this Moore case, as I said, this Tammy Moore case, the whole disappearance of Heather Elvis is maddening that it could not be solved, or has it? Well, I'm told that what I read about ducked up the phone is actually mucked up their lives on the texts that were recovered. I don't know if it means a difference. And we just heard now about liquor. I know that's there. But Nicole DeBorde, who is a phenomenal criminal defense attorney in Texas, also, as most of us were, a former prosecutor. What do you make of these texts? Again, we talked last time. Do these texts advance this case for the prosecution? Do they move the football, as I like to say, beyond the 50-yard line?
You know, I say technically maybe not, because they don't have the kind of detail that the prosecution actually needs to show that anything happened, that these folks are responsible. What they do is potentially anger the jury and dirty up the defendant. And that's definitely moving the ball down the field for the prosecution.
Well, the texts that were deleted, well, sorry, the texts that were mentioned, I believe Will Lynch, who was a detective there, said they were deleted. Why is it important, if these deleted texts are recovered, talking to her friend Christine about hating her husband, about having liquor, about having a good time for a year without him? Why is that important, that they were recovered in the delete folder or in the unallocated space folder?
You know, I think what they're trying to do is show the jurors that these people were trying to hide something. And that's the only reason that you delete things like that from your computer or your phone, because you don't want somebody else to find it later.
But let me just stop you right there. Does the fact that she's talking about chaining up her husband for a year and being single, how does that, again, move the ball beyond that 50-yard line to get to beyond a reasonable doubt, which, as you and I know, is a very difficult standard?
Sure, no, I agree. I don't think that it does. What I do really believe is that all of these sort of scandalous sounding emails that they later tried to hide by deleting look bad, and they make the defense look bad. So, you know, to that end, maybe they make a difference.
And maybe in hindsight, maybe they were proper to delete them, because exactly what is happening, the prosecution state's using them to make it look like Tammy Moore is some kind of horrid person. And as I said, as we go along in the day, it's going to get worse and worse and worse. And maybe these are the texts that have possibly moved Tammy Moore to say to the judge, I have decided to take the Fifth Amendment. Now, how strange is that? How amazing is that? How strange is that? How unusual is that? Whatever you want to call it, Nicole, in your practice.
You know, I think that it's a bold move, was one way to put it, for the defense in this case. You have a totally circumstantial case where it doesn't look like the prosecution's made a lot of headway in making solid headway in proving their case. And now you have a defendant who's saying, I'm willing to testify. And that could really be everything that the prosecution hoped for and more.
And Nicole, as you know, this is one of the two decisions that a defendant can make. The other one is whether to have a jury trial or not, right? All the other decisions we as lawyers make in the courtroom. Defendant has to make decisions, usually under the advice with a lawyer. My experience has been that sometimes you can have a problem client that you are telling them not to testify because the state has not proven their case beyond a reasonable doubt, but they want to get on the stand and tell their story. And I think we may have seen a little bit of that in the opening by the defense, who said, when they said to the jury that she's been waiting to clear her name and tell her story. And there she is on our screen right now. I know you and I talked before, you wouldn't recommend it, but how many clients have you represented who have agreed to take the stand when there is a case against them?
Who have agreed? I'd say, the good news is that the vast majority of the clients that I've had have wanted to follow the advice of their lawyer. I mean, look, they've hired you. They're investing their time and money into letting you help them understand the strategy for proceeding in their case. And most of these folks want to follow the advice of the lawyer that they chose. Every now and again, you get some client who just doesn't want to do that, thinks they know exactly.
That happens, as we know. Well, we have to go to a break. Stay tuned. Again, gavel to gavel, only here on Law and Crime. Well, that was the defense attorney for Tammy Moore on the conspiracy to kidnap and the kidnapping trial for Heather Elvis. Really grilling, but grilling in a very nice way, where he's explaining to the jury the crime scene investigator. Now, Nicole DeBorde, you know that I love this. This is like a carnival for me to listen to forensic evidence. But here, they didn't pull the seat out of the car. They didn't look for hair that may have been pulled out in a struggle or the roots. The investigator basically kind of, I don't know, what did he do? You tell me.
Right. Now, this has been a problem throughout the entire state's case. And the reality is that they just were not investigating this like a homicide. They were investigating it like an adult who wasn't really answering their phone. And that's treated very differently from a case where they suspect a homicide or maybe a child's gone missing.
But even somebody who's a missing person who maybe you think is kidnapped, you certainly want to look to see whether there's indications that they were cut. Right? I mean, you certainly want to see. I mean, the crime scene investigator here said, well, blood looks like blood. Well, I've got news for you. It doesn't necessarily look like blood. That's why we have presumptive tests for blood on the scene. And that's why you have to do DNA on things that you may think are blood. So it doesn't even appear they did the basics on Sydney's truck, which, tell me this, riddle me this. Why do you sell a truck after you may have been accused of committing a crime? You actually weren't accused of committing a crime, but you sell a truck after your girlfriend goes missing, your former girlfriend?
Got to get rid of that truck and all the evidence in it, especially if the forensic folks didn't track it. And it's gone now. And, you know, you're right. Could have collected this evidence. They were looking at this case
clue, C-L-U-E, comes to mind to me, that maybe it's a clue that you should process something pretty well. Now, what else could they have done when they think this is right on, when she's December 18th, she's reported missing. Then when she's reported missing right then, what else could the crime scene investigator have done?
The crime scene investigator could have done a much thorough job of going over the truck. They could have gone over it with swabs to collect information, little bits of evidence so that they could test them later if it became relevant.
How about they went to, during the week or some days later, they went to Heather Elvis's apartment and photographed things. Now, you know, they've had this theory, the prosecution, that she was actually kidnapped and disposed of around Peachtree Landing. I have actually a different theory on this case, that she could have been kidnapped, if she were kidnapped, a lot earlier than that those phone calls from Heather's phone to Sydney's phone may not have been Heather to Sydney in reality. So I have a different theory, that perhaps her car should have been gone through a little more, but they actually let her father drive the car home and didn't process it till later, and then really didn't process it. What could they have found out from her car?
They could have gotten samples of potential fluids. They could have gotten fingerprints. They could have tested for, they could have used luminol to see if there's any blood, traces of blood in the car. They could have gone through it and collected potential fingerprints, even though it's a car where many people may have been. You could have gathered all kinds of information from different locations in the car.
And also, it seems to me that the prosecutors made up their mind that it had to be these two alone. It's also very possible that indeed one of them or both of them or somebody could have hired somebody else to assist in her abduction if she were abducted. And if you had a third-party fingerprints on that car and her car, that would mean a lot, wouldn't it?
Sure, it would at least be somebody to talk to if you could locate that individual and have them explain why their fingerprints might be in the car. So, there's a whole lot of information that could have been collected. A lot of times crime scene units are operating in a world where they don't know what's important, and that's why they are supposed to collect everything that they can think of. They go through a very detailed
Heather, I got to cut you off because we're almost finished for the day. We could talk forever on this case. Thank you for assisting us with your great knowledge. We here at Law and Crime are going to stay tuned on this case because the best is yet to come, and the best comes right after me. That's Aaron Keller with his new show. You have to stay tuned. He'll sum it all up. Bye-bye.